Hello and welcome to this module on business laws and practice. Today, we're diving into the fundamentals and basics of some key business laws. Let's start with the Indian Partnership Act of 1932. A partnership, as defined by Section 4, is essentially a relationship between people who agree to share profits from a business, which can be run by all of them, or just one acting on behalf of everyone. From an accounting view, the partner and the firm are seen as separate. However, legally, they are not separate entities. This means a partner's personal assets can be used to pay the firm's debts. A partnership agreement or deed can be oral or written, but a written deed is definitely preferred, as it serves as crucial evidence if disputes arise. Now, what happens if there's no written partnership deed? The Indian Partnership Act of 1932 has specific provisions that automatically apply. First, profits and losses are shared equally among all partners. No interest is allowed on capital contributed by partners, and similarly, no interest is charged on drawings taken by partners. Partners aren't entitled to any salary or commission. However, if a partner provides a loan to the firm, they are allowed interest at 6% per annum. Finally, a new partner can only be admitted if all existing partners give their consent, as per Section 31. Next up, we have the Commercial Courts Act of 2015. This act was enacted to help resolve commercial disputes quickly. It establishes special commercial courts and commercial divisions within high courts. These courts handle disputes where the commercial value is 3 lakh rupees or more. The act outlines detailed procedures, including mandatory pre-institution mediation, provisions for summary judgments, and strict timelines to ensure speedy resolution. Let's look at what the Act defines as, quote, commercial disputes. It provides an illustrative list of 21 types, which can be expanded by government notification. Some examples include ordinary transactions involving merchants, bankers, or traders, export and import dealings, matters related to admiralty and maritime law, transactions concerning aircraft, construction and infrastructure contracts, disputes over immovable property used in trade, franchising and licensing agreements, joint venture and shareholder agreements, and importantly, intellectual property rights like patents and copyrights. How is the, quote, specified value of a dispute determined under Section 12? For money recovery, it's the total amount sought, including any interest. For movable property, it's the market value when the case is filed. For immovable property, it's its market value or the value of the right involved. And for intangible rights, it's the estimated market value as declared by the plaintiff. The Commercial Courts Act has a specific court structure and hierarchy, depending on the High Court's original civil jurisdiction. There are high courts with original civil jurisdiction, like Delhi or Kolkata, and those without. In high courts with original civil jurisdiction, a commercial division is constituted, usually with a single judge, handling higher value cases. A commercial court is set up at the district judge level, or even below, based on the high court's jurisdiction. Above these, every high court has a commercial appellate division, a bench of 2 or more judges, which hears appeals from both commercial courts and commercial divisions. Where high courts lack original civil jurisdiction, a commercial appellate court is established at the district level to hear appeals from commercial courts below the district judge. Moving on, let's look at the SARFAESI Act of 2002. Its primary purpose is to help banks and financial institutions recover non-performing assets, or NPAs. The Act allows creditors to take possession of collateral or sell the assets of defaulting borrowers without direct court intervention, significantly speeding up the recovery process. Enforcement of this Act is primarily done through the Debt Recovery Tribunal, or DRT, and the Debt Recovery Appellate Tribunal, DRAT. Now let's delve into the Indian Trusts Act of 1882. This act specifically regulates private trusts. A trust, as defined, is an obligation linked to property ownership, arising when one person places confidence in another who accepts it for the benefit of someone else or even themselves. There are key roles. The author, or settlor, is the one who creates the trust. The trustee accepts this confidence and manages the property. And the beneficiary is the person for whom the trust is created. The trust property is the asset involved. Importantly, a trust must be created for a, quote, lawful purpose. A purpose is considered unlawful if it's forbidden by law, defeats a law, is fraudulent, involves injury, or is immoral or against public policy. What makes a trust valid under the Indian Trusts Act? And what are the trustee's duties? For a trust to be valid, there must be a clear intention to create it, a reasonably certain purpose, a clearly identified beneficiary, and the trust property must be well defined. Trustees have several duties. They must fulfill the trust's purpose and follow directions, protect the title of the trust property, manage the property with the care of an ordinary prudent person, act impartially towards all beneficiaries, prevent waste of the property, maintain proper accounts and provide information, and invest trust money only in prescribed securities. Finally, let's briefly cover the Societies Registration Acts. The Societies Registration Act of 1860 aims to promote the formal organization of groups for literary, scientific, charitable, or other similar purposes. 7 or more people can form such a society. Registration involves subscribing names to a memorandum of association and filing it with the registrar. This memorandum details the society's name, objects, and the names, addresses, and occupations of its governing body, along with its rules and regulations. The Tamil Nadu Registration of Societies Act of 1975 builds upon the 1860 Act, adding state-specific compliance norms and oversight mechanisms. Both these acts specify comprehensive procedures for registration, ongoing management, eventual dissolution, and maintaining proper records for societies. Thank you for your attention. Hello and welcome to this module on business.